Yes, Mr. Advani.
Yes, sir. I was on paragraph 33 of the judgment.
Yes.
Just to complete it, it may also be noted that the question as to which entities are parties to the arbitration agreement is usually left to the judicial discretion, especially when there's a limited statutory guidance. There's a perception regarding the questionable sourcing of the group of company doctrine from the wording of Section 8 does not imply that it is barred from Indian arbitration law. Undoubtedly, the courts have judicial discretion to invoke and apply the doctrine in Indian judicial arbitration, in Indian arbitral jurisprudence. The earlier analysis on the interpretation of the group of company doctrine fortifies, and when formulated in its most modern sense, it does not affect the separate legal entity principle in company law. Gary, as the doctrine.
It's already read already.
Already read 34. Gary Bond we read.
Oh, sorry, sir.
You are actually 35, I think.
So just paragraph 35. It therefore appears that the current interpretation of the doctrine does not disturb or affect the separate corporate form of different entities within a group of companies. Neither does the act of piercing the corporate veil necessarily cause the separate legal entity of the third party to collapse. In this context, corporate law doctrines such as piercing the corporate alter ego are means by which to identify.
Advani, we read 41 also about the family-run businesses, and then
I'm sorry, sir. I got my mark wrong.
Only to India, but it also applies across the world. 42 completed. We'll go to 43 now.
We'll go to 43. I'm sorry, sir. The doctrine itself may also provide greater stimulus for business with new entities that are starting out. Due to the aforementioned peculiarities in Indian business relationships, newer companies have significantly difficulty in gaining traction. One of the means by which such companies can then gain a foothold is by being part of a large, often family-owned group of companies. The new entities are then able to feed off the goodwill or relations that larger companies have with the rest of the business world. Given that the connection to larger groups is intrinsic in the way which business is conducted, arbitration law must acknowledge and address this reality. In fact, the tribunals have already recognized the reliance that is often placed by a company upon the conduct of the non-signatory parent company when entering into the agreement with a subsidiary. The tribunal in so-and-so, under the aegis of Arbitration Institute of Stockholm and Chamber of Commerce, is a prime example of international arbitration grappling with this issue. Therein, the Arbit Tribunal noted that the Yukos Oil, with its via its action, that created an expectation in the mind of Petro Alliance that was willing to and ready to back up, step into the places of its subsidiary YNG, with which Petro Alliance had entered into a contract. While there were several factors that contributed to the decision of the tribunal to bind Yukos to the arbitral proceedings, the most relevant takeaway for our purposes is the manner in which the tribunal enunciated the theory of trust that exists under Swedish contract law. The important consideration of the theory is similar to the company law principles, such as an alter ego is not the actual intent of the party as a non-signatory, may be acting duplicitously or to represent itself as a driver of the contract while avoiding any liabilities arising from it by not signing the contract. Hence, what the theory examines is that the intent the non-signatory has conveyed to a reasonable party in the same position as the contracting entity. The decisive factor is the extent to which the contracting party has placed trust in the other party reasonably and on the basis of non-signatory action. To clarify, the wholesale adoption of Swedish theory of trust into Indian law is not being advocated. Rather, the notion of how we may apply the group of company doctrine in situations when non-signatory parties are acting in a fraudulent or deceitful manner can be addressed by examining the impression that was conveyed to the contracting parties by the third party. This is the addition to the already well-established principles of piercing the veil and alter ego. This may also address a legitimate critique of chloro controls and Cheran properties that despite placing an emphasis on legal standards of intent, the court eventually resorted to the principles of equity, commercial, economic expediency to apply a group of companies doctrine in those cases. Conclusion. In view of the above discussion, respectfully, I am of the opinion that the questions that are sought to be referred to a larger bench deserve further elaboration. With all humility at my command, the following substantial questions of law also arise for authorities for determination by a larger bench in addition to the conjunction with those formulated by the Honorable Chief Justice.
It seems to have started today.
Yeah.
Yes.
A. Whether the group of company doctrines should be read into Section 8 of the Act or whether it can exist in Indian jurisprudence independent of any statutory provision. Whether the group of company doctrine should continue to be invoked on the basis of the principle of single economic reality. C. Whether the group of company doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. D. Whether the principle of alter ego and or piercing the corporate veil can be alone justify pressing the group of companies doctrine into operation even in the absence of implied consent. So may I just show one other judgment, a very small part of it. It's an Ontario court judgment which talks about the model law.
Mr. Advani, now why don't we look at the matter as a matter of first impression, and you can develop it from the statute, then show us some of the law, including some of the judgments of our court, and you can then make your submissions. That may be a good idea, because instead of us looking at just comparative law without looking at our own statute, may be a little problematic. So let's look at our statute, see how you want to evolve the doctrine of this doctrine, the group of companies doctrine, in the context of our statute. Where do you really found that doctrine? How do you sort of read that doctrine into the statute?
So as I indicated,
first, 8 and 45 may not really be relevant, because 8A applies to the party which is seeking a reference to arbitration. Likewise, 45 applies to a party or party claiming fruit which is seeking a reference to arbitration. Whereas a group of companies doctrine also applies to a situation where you are seeking to hold, apart from your counterpart, the counterparty, someone else as liable under the contract, apart from the signatory to the agreement. So 8 and 45 in that sense, so the amendment to 8 may not be to that extent very material. Of course, it's broadly an indicator that they brought 8 at par with 45 when in the 2015 amendment. But how do you now look at the statute? First, tell us, how do you look at the statute and then interpret it?
So may I just
do one each, yes.
For that, I draw your attention first to the Article 2 of the New York Convention, sir.
To the
New York Convention was shows.
Should we not look at the statute, the Indian statute straight away?
Very well. So then if we go to section 7, sir, for a moment.
7, 8, and 2.
Let's look at section 2 first.
I'll go to section 2 first, sir. So 2 is definition. In this part, unless a contract otherwise requires, arbitration means any arbitration, whether or not administered by a permanent arbitral institution. Arbitration agreement means an agreement referred to in section 7. Then, so the relevant definition here will be of, just give me one moment, the party.
Yes.
I'm just giving party, the 21H, sir.
Yes.
Party means a party to an arbitration agreement. So,
Yes.
just pausing you for a moment, sir. What now, the Law Commission's opinion?
It's very interesting. It says party means a party to an arbitration agreement. Yes, the party in the first part cannot be equated with the party of the second part, isn't it? Or does it mean the same thing?
And so, therefore, what the Law Commission expressed its view.
What do you mean by party? Party in 21H, does party, I mean, reading it in a very strict sense, it will mean a signatory to an arbitration agreement. Intent. If you were to read it in a strict sense, very strict sense. Someone executed the arbitration.
So if you see the wording doesn't use the word signatory.
Right, exactly.
It doesn't.
That's what you're right. That's
It
exactly
means
the point I was
party
saying.
to an arbitration agreement.
Is what you're saying.
Yes.
And therefore, so the Law Commission, when it was giving its opinion, also expressed the view that the party should not be construed narrowly, but it means anybody who is, in that sense, consented to the agreement or acted on the agreement. It should not be construed narrowly. This is the opinion given by the Law Commission.
And nevertheless, the party, the expression there, it doesn't require an interpretation. If you just read this statute as it stands, party to an agreement. So obviously a party who has signed the agreement, I mean, we are just looking at this particular provision right now.
I presume, but what if he impliedly consented to the agreement, sir?
All
If
right.
if a party had impliedly consented
a signatory to an agreement or the executant of the agreement would be a party. That is very clear.
Yes, sir, but it is not confined to that. That is why the definition of party, as suggested by the Law Commission, was that it would include anybody who impliedly consented to the agreement. It is an implied consent, it is also a party.
Where does the Law Commission say that?
If you see Justice Ramana's judgment, he quotes the Law Commission on that.
Do we have the Law Commission report here? In the commission?
Yes, ma'am. It's
Just give me one moment, sir. I'll find it.
starts from page 270 of the compilation. And
270 of the compilation. Okay.
the relevant paragraph starts from page number
Convenience complaint.
It's,
307 on.
307.
Para
Yes,
6.
sir.
This is convenience compilation by Mr. Divakant Lavati, right?
Come back with the page again.
The Law Commission report starts from page number 270.
so the relevant page is 307, sir.
PDF 309.
Yeah.
So if it's PDF
Definition of party.
9 PDF.
Which report was this? Rishi मिल गया आपको?
309.
PDF page 309. Jamshid, you got it?
309. 309.
PDF is the PDF page, madam.
Manoj, you got page 309.
Definition of party is what you are at?
Yes.
Yes.
Yes, sir. Yes, sir.
Yeah.
309.
So do we all have it? So my paging is 307.
All right. You mean the page on the right hand side?
Yes, sir. Page on the right hand side.
Yes, we got it.
It's paragraph 61, definition of party.
Yes, please read it out.
Do we all have it, sir?
Yes.
May I just read? Arbitration is a consensual form of dispute resolution with the arbitral tribunal deriving powers and authorities on the basis of the contract or the agreement between the parties. This agreement has far-reaching consequences. It takes away the right of the party to the arbitration agreement for various remedies in a court of law for resolution of the disputes covered by the terms of the arbitration agreement and makes the consequences of the award binding with a limited right of recourse in terms of Section 34 of the Act. It would thus be incongruous and incompatible with this consensual and agreement-based status of arbitration as a method of dispute resolution to hold persons who are not party to the arbitration to be bound by the same. However, a party does not necessarily mean only the signatory to the arbitration agreement. In appropriate context, a party means not just a signatory, but also persons claiming through or under such signatory. For instance, successors of interest of such parties, alter egos of such parties, etc. This is particularly true in the case of unincorporated entities, where the issue of personality is usually a difficult question and raises a host of other issues. This principle is recognized by the New York Convention 1985, which in Article 2.1 recognizes an agreement between the parties in respect of a defined legal relationship, whether contractual or not. The Arbitration and Conciliation Act 1966 under Section 7 borrow the definition of the arbitration agreement from the corresponding provision at Article 7 of the Universal Model Law, which in turn borrowed this from Article 2 of the New York Convention. However, the definition of the word party in Section 2(1)H refers to a party to mean a party to an arbitration agreement. This cannot be read restrictively to imply a mere signatory to an arbitration agreement, since there are many situations and contexts where even a non-signatory can be said to a party to an arbitration agreement. This was recognized by the Honorable Supreme Court in Chloro Control versus Swen Trent Ward Application, where the Honorable Supreme Court was dealing with the scope and interpretation of Section 45 of the Act, and in that context discussed the scope of the relevant doctrines on the basis of which a non-signatories could be said to be bound by the arbitration agreement, including in case of interrelated contracts, group of companies doctrine, etc. This interpretation given by the Honorable Supreme Court follows from the wording of Section 45 of the Act, which recognizes the right of person claiming through or under a party to apply to the judicial authority to refer to the parties to arbitration. The same language is also used to be found in Section 54 of the Act. The language is, however, absent in corresponding provision of Section 8 of the Act. It is similarly absent in other relevant provisions where the context would demand the party also include the person claiming through or under such a party. To cure this anomaly, the Commission proposed amendment of the definition of party under Section 2(H) of the Act. So the Commission recognizes a broader definition, and they say, just to, so to speak, close the gap, we recommend an amendment to 2. That 2 was not amended, but
Let
they
us see
recognize.
7.
Now we'll go to 7.
7, very important. The definition must be read in the context of 7.
Yes, sir. Arbitration agreement. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. These are the same words taken from the New York Convention. And so some meaning must be attributed to the defined legal relationship, whether contractual
Please read
or not.
further.
Just read on, just read
Please
on,
read on, it's very important because the express is important.
An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing.
That's it.
An arbitration agreement is in writing if it is contained in a document signed by the parties. An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement, or an exchange of statements of claim and defense, in which the existence of arbitration of the agreement is alleged by one party and not denied by the other. A reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such to make the arbitral clause part of the contract.
So if a arbitration agreement does not contemplate a particular party, can we still say that it's an arbitration agreement?
Yes, sir, that's what the
Implication.
Section 2 says.
By
Section
implication.
2 says that an arbitration agreement may be in the form of an arbitration clause, a contract, or in the form of a separate agreement. So all that it contemplates is a written agreement.
But that will not help you because it need not be in that it may be in the form of an arbitration clause in a contract or in a separate agreement.
That's
But
right.
it has to be an
But it does
agreement in writing.
This is departure from the Contract Act, which contemplates the existence of an agreement which can be implied also. So Arbitration Act does away with that and says an arbitration agreement must be a written arbitration agreement. So now once an arbitration agreement is a written agreement, is it possible for a court to infer inclusion of a third party in the agreement by implication?
So that's why, sir, that in the definition of party, the definition of party is just it can be implied by implied term. It does not have to be a signatory to the contract.
Also something in say 4B. So when 4B says an arbitration agreement is in writing if it is contained in B, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. So if there is a written course of written communication between the parties, by virtue of which a party which is otherwise not a signatory to the agreement has evinced an intent to be bound by the arbitration agreement, then possibly then.
And C5 also. The reference to a contract.
To a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference to such is to make arbitration clause part of the contract. So there are.
So one thing, Mr. Advani, is very clear that can you say that a third party which is not a signatory to a written agreement would be bound merely by conduct
or correspondence.
When there is actually a
Unless it is.
Say,
agreed correspondence?
You see, conduct, as the Learned Chief Justice has pointed out, not only just conduct, but correspondence, as it is pointed out in clause 4B, but which provide a record of the agreement, that has to be also satisfied. After all, these are all commercial transactions. I mean, somebody who you expect to fulfill a part of the contract has actually committed to fulfill that part of the contract, and yet you don't insist on an agreement.
I appreciate that, sir.
Hard-nosed commercial contract. I mean, you are asking, I mean, for the arbitration to trigger in that implied agreement, etc.
So therefore, sir, what I was going to suggest is 7.1 is a governing clause, sir. 7.1 is a overall governing clause which goes on to say that this part of the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen, which may arise between them in respect of a defined legal relationship, whether contractual or not.
Now, interestingly, the Law Commission recommended that 2H should also be amended, which was never amended, at par with 8.
But sir, the Law Commission in paragraph 62 on page 308 goes through this whole exercise and in terms says, however, party does not mean only a signatory to the arbitration agreement. That's a general view taken by the Law Commission, sir. Although they said to close the loophole, we suggest clause 2 also be amended.
They also relied on chloro-control.
They also relied on chloro-control.
The correctness of chloro-control is now at large before us.
I appreciate that they relies on chloro-control, sir, and
because they say it does not only mean a signatory. That you are right, because if the legislature wanted to use the word signatory, they would have used the word signatory.
right.
Into 1H. So the absence of the use of the word signatory and a reference to a party to the agreement is of some significance. But equally, then you have to read it in the context of 7, because 7 specifically says that it has to be an agreement in writing.
So this is clearly departure from section 10 of the Contract Act, which qualifies the definition of an agreement evolving into a contract, and says that it need not be a written agreement specifically.
Therefore, suit for specific performance of an agreement to sell can be a
Correct.
suit for specific performance of an oral agreement to sell as well. There's no requirement in law that your contract of which performance is sought is a written contract.
You may just point out, just on a side, most of this concept of group company documents have originated from awards. They have not originated from interpretation by the agreement by the courts. And that period discovery was.
He's not in.
He should tell us why the Law Commission recommendation, so far as the definition is concerned, was not
2H.
carried out. 2H. Just somebody must convey it to him.
So may
Was it overlooked or was it something deliberately they didn't?
Yes, but separately, I'll make my submissions.
So may I just draw your attention to one judgment of the Supreme Court which has considered this issue.
All right.
This is the decision of MTNL versus Canara violation. It starts at page 158 and it considers these issues on from
PDF
page
160. MTNL.
166.
It's MTNL versus Canara Bank.
Yes, Manoj.
Just Hindu Malhotra. Yes.
Page number 166, Maharaj. Para 9 on.
We got it.
The existence of a valid arbitration agreement.
Yes, Mr.
So if we go to the judgment of MTNL versus Canara Bank, on page 166 of our compilation, paragraph 9. A valid arbitration agreement constitutes the heart of an arbitration.
Page 166.
Page 166, paragraph 9.
Yes.
A valid arbitration agreement constitutes the heart of an arbitration. An arbitration agreement is a written agreement between the parties to submit the existing or future disputes or differences to arbitration. A valid arbitration agreement is the foundation stone on which the entire edifice of the arbitral process is structured. A binding agreement or dispute to be resolved through arbitration is sine qua non for referring the parties to arbitration. Section 7 defines the arbitration agreement as under. I'm not reading the definitions, we've just seen it. If we go to the next paragraph 9.2, the arbitration agreement need not be in any particular form. What is required to be ascertained is the intention of the parties to settle their disputes through arbitration. The essential elements or attributes of an arbitration agreement is the agreement to refer their disputes or differences to arbitration, which is expressly or impliedly spelled out from a clause in an agreement, separate agreement, or documents correspondence exchange between the parties. Section 7.4 states that the arbitration agreement can be derived from an exchange of letters, telex, telegram, or other means of communication, including through electronic means. The 2015 Amendment Act inserted the words including communication through electronic means. In section 7.4b, it can prima facie be shown that parties are ad idem even though the other party may not have signed the formal contract and cannot absolve himself of liability under the agreement. Arbitration agreements are to be construed according to the general principle of construction of statutes, statutory instruments, and other contractual documents. The intention of the parties must be informed from the terms of the contract, conduct of the parties, and correspondence exchange to ascertain the existence of a binding contract between the parties. If the documents on record show that the parties were ad idem and had actually reached an agreement upon all material terms, then we construe to be a binding contract. The meaning of a contract must be gathered by adopting a common sense approach and must not be allowed to be thwarted by a pedantic and legalistic interpretation. A commercial document has to be interpreted in such a manner so as to give effect to the agreement rather than to invalidate it. An arbitration agreement is a commercial document inter partes and must be interpreted so as to give effect to the intention of parties rather than to invalidate it on technicalities. In so-and-so case, the court, while ascertaining the terms of an arbitration agreement between the parties, held that if on a reading of the documents as a whole, it can be fairly deduced from the words actually used therein that the parties had agreed on a particular term, then nothing in law which prevents them from setting up that term. The terms of the contract can be expressed or implied from what has been expressed. It is an ultimate analysis, a question of the construction of the contract. In interpreting or construing an arbitration agreement or arbitration clause, it will be the duty of the court to make the same workable within the permissible limits of the law. This court in so-and-so held that a common sense approach has to be adopted to give effect to the intention of the parties to arbitrate the disputes between them in a commercial contract. The arbitration clause cannot be construed with a purely legalistic mindset, as in the case of a statute. In this case, MTNL raised a preliminary objection that there was an arbitration agreement in writing between the parties. At this stage of the proceeding, we will deal first with this issue. The agreement between MTNL and Canara Bank to refer the dispute to arbitration is evidenced among the following documents exchanged between the parties in the proceeding. So those are the facts of that judgment. So I won't trouble you with that one, sir. So if you go to the relevant page on
198 discovery.
No, on this. Then if you go to paragraph 10, sir, joinder of Canfina and the arbitral proceedings. Canara Bank raised an objection to the joinder of respondent number 2, Canfina, the party to the arbitration proceedings. As per the principles of contract law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. The parent of the subsidiary company entering into an agreement unless acting in accord with the principle of the agency or representation, will only be an entity in the group to be bound by that agreement. Similarly, in arbitration is also governed by the same principle, and normally the company entering the agreement will alone be bound by it. A non-signatory can be bound by an arbitration agreement on the basis of group company document where the conduct of the parties evidences the clear intention of the parties to bind both the signatory as well as the non-signatory parties. Courts and tribunals have invoked the doctrine to join a non-signatory member of the group if they are satisfied that the non-signatory member of the group or by reference to a common intention of the parties a necessary party to the contract. So what is being suggested is to interpret all this in a commercial manner. And if you see where the origin of where did the origin of the group company comes, it came in through arbitration awards, not through court judgments. When the arbitral tribunal in the Dow Jones case comes first to a conclusion that, look, this is because of the way Dow Jones is constructed as a group, that they can be made parties to arbitrations, the court then affirmed that principle. Even in the Ontario judgment, which I was going to show you, to your lordship, there was again an interpretation of the arbitration award that one of the other parties is rightly made the arbitration agreements. And then they deal with the UNCITRAL law. It says the UNCITRAL law is meant to decide disputes between the parties in an expeditious manner. Therefore, the interpretation must be more liberal, and therefore we hold the award is right. So the origins of some of these situations did come from the facts of the case and sometimes considered by the arbitral tribunal, and said it is appropriate that people are implied members or they participate in the contract or they're acting together, and then the courts have upheld the principle. So even Justice Malhotra, when she takes the view, please treat these as commercial documents and read them in a commercial manner and not in a legalistic and tight manner. And therefore, the article of the New York Convention and Section 7, which override, says whether contract defined relationships, whether contractual or not. They use those very wide words to enable courts to consider whether in an appropriate case or not it should be done. And that, in fact, was ultimately going to be one of my propositions to your lordships, that your lordships, when deciding a section 11 or 8, where they say the parameters are the same, will take a prima facie view of all the parties, have they participated in the contract either by conduct, intent, or different manner financially. We'll take a practical view and then leave the details to the arbitral tribunal to decide. Because ultimately they are subject to Section 16 applications. The courts will take a prima facie view, a broad view of the definition of party. The court will take a broad view of the courts will take a broad view of the definition of party. The Law Commission has taken a particular view. If you look at Section 17, they also say contractual or defined relationship, whether contractual or not. And that should be the discovery thing. Paragraphs. So may I show your lordships quickly one? May I show your lordships one more judgment, Vinod?
Yes.
This is the Discovery Enterprises on page 198. The relevant portion is on page 198 of my compilation.
And also show us this Charan.
I'll come to Charan. So I'll just finish with this and I'll come to Charan after that. Your Lordships have page 198.
Yes.
May I just read from paragraph 20, sir? Section 7 provides for an arbitration agreement. For the purpose of the agreement.
Just a minute,
Yeah.
just a minute. Your pages, there's a bit of a,
It's actually 200. Page 3.
just a minute. Yes.
Did your Lordships have it? It's paragraph 20. Group of companies doctrine. Section 7 provides for an arbitration agreement. For the purpose of part 1 of section 1996, the arbitration agreement defined to be an agreement between the parties to submit dispute between them in respect of a defined legal relationship to arbitration. An arbitration agreement may either be in the form of an arbitration clause in a contract or take the form of a separate agreement. An arbitration agreement has been in writing, but it may be contained in. So then we are quoting that. Then we go to paragraph 21. Section 5 of the section 7 stipulate that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is written and the reference is such as to make the arbitration clause a part of the contract. The expression party is defined in section 218 in a party to an arbitration agreement. The interpretation of the term parties vis-a-vis an arbitration agreement under section 7 as we dealt with by this court, by this court in Indo-Wen in the context of application from the point of view of the arbitrator under section 11.6. In that case, the second respondent was the promoter of Indo-Wen. The first and second respondent entered into an agreement for sale. In the agreement, the seller was described to include the respondent and his subsidiaries. The second respondent was described as a buyer and as the promoter of the Indo-Wen. Under the agreement, the seller agreed to transfer the business of assets for consideration, which was partly payable in money and partly by the issuance of shares. The sale agreement also incorporated a clause to arbitrate any dispute. The board of directors of the first and second respondent approved the agreement, but there was no approval by the board of Indo-Wen. After a dispute arose, the first respondent instituted a petition under section 11.6 against both the second respondent on the ground that it was not a party to the argument between the first and the second respondent. The application was allowed by the Chief Justice of the Madras High Court by observing that prima facie Indo-Wen was a party after lifting the corporate veil and noticing Indo-Wen's intention to be bound by the sale. Two issues were framed by the court for consideration, so and so. So then paragraph 23, the relevant one. R.V. Ravinan J, speaking for the judgment in Indo-Wen, held that if Indo-Wen had acknowledged or confirmed in any correspondence, agreement, or document that was a party to the arbitration agreement between the first and second respondent, or that was bound by the arbitration agreement contained in the contract, it would have been possible to say that Indo-Wen is a party to the arbitration agreement. Your Lordship, remember, this was before the amendment.
Yeah.
The judge expressed this view. The learned judge expressed the view before the amendment to Section 8, saying that if there was any correspondence or anything of that sort saying it was party to the contract, then it could be construed to make them a party to this arbitration. But because of the lack of correspondence, etc., it could not be done. And don't forget, this was before the amendment to Section 8. It couldn't have been possible to say that Indo-Wen is a party to the arbitration agreement. That, however, was not the position. The decision Indo-Wen was in context and application under Section 11.6, a party with. Therefore, so the
Third.
I was just pointing out that observation that even mark the portions properly.
Yes, Mr. Advani.
Now, in the same judgment, could your lordships go to paragraph 29 where Cheran Properties is considered?
Right.
In Cheran Properties, a three-judge bench of this court.
You said that 29.
It's on page 202 of our compilation, sir. In Cheran Properties, the three-judge bench of the Supreme Court interpreted and applied the group of company doctrine in the context of the enforcement of a domestic arbitration award against a non-signatory to the arbitration agreement. The court observed that the decision by the two-judge bench in Indo-Win was rendered before the evolution and application of the group company doctrine by a three-judge bench in Chloro Control. As the law has evolved, it has recognized that modern business transactions are often effectuated through multiple layers in agreement. There may be no transaction within a group of companies. The circumstances which they've entered into may reflect an intention to bind both the signatory and the non-signatory entities within the same group. In holding a non-signatory bound by an arbitration agreement, the court approaches the matter by attributing to the transaction the meaning consistent with the business sense it was intended to be ascribed to them. Therefore, factors such as the relationship of a non-signatory to a party which is a signatory to the agreement, the commonality of the subject matter, and the composite nature of the transaction weigh in the balance. A group of company document is essentially intended to facilitate the fulfillment of a mutually held intent between the parties. Where the circumstances indicate that the intent was to bind both signatories and non-signatories, the effort is to find out the true essence of the business arrangement and to unravel from a layered structure of commercial arrangements and then to bind someone who is not formally a signatory but has assumed the obligation to be bound by the actions of the signatory. This court in Cheran Properties also analyzed the academic literature and scrutinized the adjudicatory trends across the world. It noted that the written intention to arbitrate between the parties can extend to bind non-signatories with the aim to target the credit-worthy member of the group of companies. However, the principle of separate legal personality of the company also has to be balanced. The corporate veil can be pierced to bind non-signatories upon a construction of the arbitration agreement, the intention at the time of entering into the contract, and the performance of the underlying contract. Does the requirements of Section 7 that an arbitration agreement be in writing exclude the possibility of binding third parties who may not be signatories to an agreement between the two contracting entities? The evolving body of academic literature as well as adjudicatory trends indicate that in certain situations an arbitration agreement between two or more parties may operate to bind other parties as well. Redfern Hunter explained the theoretical foundation of this principle. The requirements of a signed agreement writing, however, does not altogether exclude the possibilities of an arbitration agreement concluded in proper form between two or more parties also binding other parties. Third parties to an arbitration agreement have been held to be bound or entitled to rely on such an agreement in a variety of ways. First, by operation of the group of company doctrine, pursuant to which benefits and duties arising from the arbitration agreement may in certain circumstances be extended to other members of the same group of companies. And secondly, by operation of general rules of private law, principally on assignment, agency, and succession. The group of company doctrine has been applied to pierce the corporate veil, to locate the true party and interest, and more significantly, to target the creditworthy member group of companies. Though the extension of the doctrine is met with resistance on the basis of legal imputation of a corporate personality, the application of the doctrine turns on a construction of the arbitration agreement and the circumstances relating to the entry into the performance of the underlying contract. This court in Cheran Properties also distinguished the principle laid down in Chloro Control from its application in this context of Section 11 in so-and-so judgment. The bench of the court refused to direct a joint arbitration in 5 different contracts between sister companies of one of the parties of the original arbitration agreement by respecting the conscious intentions of the parties to subject themselves to separate arbitration agreements under the individual contracts. The court in Cheran Properties distinguished the actual situation jura fergoro by discerning the mutual intention of the parties and the performance of the contract. The principle which underlies Chloro Control is that an arbitration agreement which is entered into within a group of companies may bind non-signatory affiliates. The circumstances are such as to demonstrate the mutual intention of the party to bind both signatories and non-signatories. In applying the doctrine, the law seeks to enforce the common intention of the parties when circumstances indicate that both signatories and non-signatories were intended to be bound. In Juro, the case was held to stand on a different footing since all 5 different packages as well as corporate guarantees did not depend on the terms and conditions of the original package, nor on the memorandum of understanding executed between the parties. The judgment in Juro does not detract on the principle which is enunciated in clause of control. The group of company doctrine was subsequently applied by the judge bench of this court in bracket Beniska versus Reinders for deferring of if a non-signatory to a foreign company then the same group of companies could be impeded in a domestic arbitration. The court noted the principles formulated by this court in Cloro Controls and Cheran Properties and noted its inapplicability after assessing the following. The alleged common employee between the two companies in the same group was factually established as having no connection with the foreign company. A mere existence of an indemnity by a foreign company in the absence of other factors would not signify the intention to be bound by the arbitration agreement and not deriving benefits from the performance of the underlying contract. In MTNL 2, a judge when the court was considering a situation in which MTNL had floated certain bonds to Can Bank Financial Service Limited, Canfina, through a memorandum of understanding. This bond amount was placed in FD by MTL with Canfina. Canfina paid back part of the amount of the FD while the rest was not paid to MTNL. The consequence, the MTNL did not service the interest on the bonds. Okay, Your Lordship says that the courts have dealt with the concept of agreement and parties both. Both Section 2 and Section 7 have already been interpreted by the courts, and they said because these are commercial contracts are interpreted broadly. And in interpreting them broadly, they have seen there are certain circumstances where it is appropriate to apply the group company document, and in certain circumstances it will not be applied. So the question that comes before Your Lordship is, when should this be done? When Your Lordship is either sitting in either Section 11 or 8 to arrive at a prima facie view, it's obvious that the other company was involved. That's the first we can see. And then let the arbitrator decide the realities of the situation, whether it's through evidence, whether it's through
Mr. Advani, this principle of prima facie would not be of any help here, because you are making somebody a party to the proceedings. That's the call that the Section 11 court will take when an application is made. So to be made a party or not to be made a party is final.
And it's not final. Your Lordship would appreciate that the party, if he feels is inappropriately made, is the prima facie.
Are you suggesting that after a court takes a decision as to a third party should be made part of the agreement and matter be referred to arbitration, and thereafter the arbitrator will take a decision as to whether he is necessary party or not? Is there a second stage like that of what has been provided in other judgments? Section 11 stage.
With all due respect, what that earlier judgment of withdrawal earlier says, that the court should take a prima facie view, and then a party is not bound, the arbitrator is not bound, because the party can take out an application under Section 16 and say, I should be discharged. It is open to him to take out an application under Section 16, say, that is a prima facie view taken by the court. That's correct. I'm before you. I'm appearing before you. But I have a right to satisfy you. In fact, I have nothing to do with this contract at all. I'm not connected with it anyway. And that is a decision under Section 16 the arbitrator can take. He's not in any sense overruling a court decision. The Lordship will see that the courts have repeatedly said that for Section 11 or 8, take a prima facie view.
Section 11 decision, whether these
Section 16 of the I.
Yes, Mr. Advani.
Yes, my lord.
Yes.
Now, therefore, I'm saying your lordship seen that video, Jola. That is why the lordships apply the same standard, saying take prima facie view on section 8 and 11. If there's an arbitration agreement, once the court finds an arbitration agreement, parties are referred to arbitration. Then the arbitral tribunal can go into the issue whether one of them is a proper party or not a proper party to the arbitration.
But at the section 11 stage, how does the court determine as to whether a third party will be bound? You are saying it will be a prima facie determination?
Yes, my lord. Otherwise, that is the role of the arbitrator. There may be evidence to decide one way or the other.
Exactly.
That's right.
The arbitrator may consider evidence of all the correspondence.
Therefore, the 11 court can't decide this at all. I mean, the 11 court cannot then go into render a final determination.
Correct.
Or a conclusive determination.
With all due respect, the court will determine on a petition and an application without seeing the evidence. Some evidence, prima facie evidence, your lordship will look at correspondence. But if there's oral evidence on this issue, your lordships are not going to go into oral evidence on 11 to consider whether it's right to put the parties in arbitration or not. If we say that they made all sorts of commitments, they made all kinds of oral commitments, and then the arbitrator will come to findings of fact on that. That is why your lordship see that decision of Vidya Jola, which I'm not carrying with me, where they say take a prima facie view on this.
Is Drolia part of your compilation?
No.
No, sir, but it was quoted in Justice Ramana's judgment. If I may just take that out, sir.
We'll take Dolia.
We'll pull it out.
We'll pull up it.
Just give us a citation of Dolia from Justice Ramana's judgment.
I'll just give it in a minute, sir. Just give one.
It was 2021, 2 SCC, age 1. 2021, 2 SCC, age 1.
If your lordship see Justice Ramana's judgment, paragraph 42. Your lordship have just paragraph 42 of Justice Ramana's judgment. Lordships will see paragraph 239 and 240 of that judgment of Vidya Jola.
Para?
Para 239 and 240. That has been quoted by Justice Ramana also, but
No, that is, we'll have to see Justice Sanjeev Khanna's judgment. That is.
yeah, I appreciate that. If your lordship will look at para 239 and 240 of the Vidya Jola judgment.
That's a concurrent judgment.
In 239, he says in terms. In a multi-party arbitration, there is complicated factual questions which are best left for the tribunal to handle. And in 240 also, sir. They take a prima facie view.
Finality. Since para 20.
Online judgment.
But yeah. Just
Maybe 147.5. 147.
this is
The Lordship will see also paragraph 231 with the recommendation to the Law Commission, sir.
Yes, yes. You are referring to Mr. Advani? Yes, Ramana? 238 and 239.
And 231 also, so the Law Commission recommendation, if I may read it, sir.
Yes.
Paragraph 231, the 246 Law Commission report in respect to the scope and nature of pre-arbitral and judicial interference states is under. The Act recognizes situations where intervention in the court is envisaged in the pre-arbitral stage, i.e. prior to the constitution of the arbitral tribunal, which includes section 8, 9, 11 in case of part 1 arbitration and section 45 in case of part 2. Section 8, 45 and section 11 relating to the reference to arbitration appointment of the tribunal directly affect the constitution of the tribunal and the functioning of the arbitral proceedings. Therefore, the operation has a direct and significant impact on the conduct of the arbitration. Section 9 being solely for the purpose of securing interim relief, although having the potential to affect the rights of the parties, does not affect the conduct of the arbitration in the same way as do the other provisions. It is also in the context the Commission has examined and deliberated the working of these provisions and proposed certain amendments. The Supreme Court has occasion to deliberate upon the scope of and nature of permissible pre-arbitral judicial reference, especially in the context of Section 11 of the Act. Fortunately, however, the question before the Supreme Court was framed in terms of whether such a power is a judicial or an administrative power. It obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e., the scope of arguments which a court, Chief Justice, will consider while deciding whether to appoint an arbitrator or not, i.e., whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and of which these it will leave for the decision of the arbitral tribunal. The nature of such intervention, i.e., would the court, Chief Justice, consider the issue upon a detailed trial and whether the same would be decided finally or be left for the determination of the arbitral tribunal. After a series of cases culminating in the decision of SPP and Company, Mr. Patel and the Supreme Court held the power to appoint an arbitrator on Section 11 as a judicial power. The underlying issue of the decision relating to the scope and intervention was subsequently clarified by Ravindra and Jain and so and so. In relation to the nature of intervention, the exposition of the law is to be found in the District Supreme Court in Shinitsu in the context of Section 45, where the Supreme Court has ruled in favor of looking at the issue's controversy only prima facie. It is in this context that the Commission recommends amendments to Section 8 and 11 of the Arbitration and Conciliation Act. The scope of the judicial entry is only restricted to situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Insofar as the nature of intervention is concerned, it is recommended that in the primary arbitration agreement it shall appoint the arbitrator and now refer the arbitration as the case may be. Amendments envisage that the judicial authority shall not refer to the parties to arbitration only if it finds that there does not exist an arbitration agreement or that is null and void. If the judicial authority is of the opinion that the prima facie the arbitration agreement exists, then it shall refer the dispute to arbitration and leave the existence of the arbitration agreement to be finally determined by the arbitral tribunal. However, if the judicial authority concludes that the arbitration agreement does not exist, then the conclusion will be final and not prima facie. The amendment also envisages there will be a conclusive determination as to whether the arbitration agreement is null and void. In the event the judicial authority refers the dispute to arbitration and or appoints an arbitrator under Section 8 or 11 respectively, such a decision will be final and non-appealable. An appeal can be maintained only under Section 37 in respect of refusal to appoint arbitration. The difference of statutory language provided in the amended Section 8, which says refer the parties to arbitration unless it finds that prima facie no valid arbitration agreements, in comparison with amended Section 11A, creates disparities which need to be ironed out. When the court in Shinetsu and Eurofero recommended finding a valid arbitration agreement on a prima facie Section 11, however, under the amended Section 8 for arbitration exists, it is to be noted that the noting of the non-existence of the arbitration agreement is final subject to appeal process only without further scope of arbitral tribunal to decide anything. And that we know for the reference, that be the case in the use of the phrase prima facie stand at odds with established precedents and prima facie standard. In this context, we
Yes. Yes, Mr. Advani, yes, we've seen para 239 now. 239 also you see, where they actually refer to fluoro controls.
Right. Yeah, whether a multi-party arbitration raises complicated factual questions which are best left for the tribunal to handle. So your lordships, when coming to a conclusion to appoint or not to appoint an arbitrator,
So he means.
The date of the reference in this matter?
6th May 22.
6 May 20.
The 6th May 2022.
But the SLP of 2020.
2020.
2020. Now, Mr. Advani, anything else?
I just wanted to show you that Ontario judgment of the practical view they take in terms of the UNC trial model law, sir.
Why don't you put that in your note, Mr. Advani, now?
I'm happy to do so, but I can point it out to you in 2 minutes. It's only 2 paragraphs, sir.
All
What's the
right.
page numbers?
What's the page in the compilation?
Yes, I'll just give it to me 1 moment. I'll get done.
This is the Canadian.
So I don't want to go into too much detail. Page 240 goes into the facts of the case of adding a non-signatory. Then the final conclusion, your lordship will find on page 243.
240 is some, 240 is some judgment of the Ontario Supreme Court.
Yes, my lord. Yes, yeah. Ontario Superior Court, yeah.
Where does it begin? Actually, it begins at page
235.
237, yes. 237.
And sir, if you go to paragraph 44 on page 243. Legally, as the panel set out in its award, there's ample authority that the model law should be given broad remedial interpretation consistent with the public policy that parties who agree to resolve the disputes by arbitration should be held to that bargain.
Where are you reading, Mr.
Which para?
Mr.
Paragraph 44 on page 243.
Para 37.
Para 44. 45.
Paragraph 44 sir, is the relevant one.
Yes.
Legally.
Legally, as the panel set out in its award, there's ample authority that the model law should be given a broad remedial interpretation consistent with the public policy that parties who agree to resolve their disputes by arbitration should be held to that bargain. As the panel noted that none of the cases that Xerox cited to it, which are the same cases cited in this appeal, deal with the interpretation of model law. Admittedly, the same is true of the case of MPI cited the panel. Those cases do not support the panel they award to join a parent company where the parties intend to involve them in resolution of disputes arising from a particular contract. Then they go on to the leading case of Dow Chemical. That I don't want to go say. In this case, also, they held a non-signatory as the party, and the court took the broad view that look at the UNCITRAL model law, it will resolve the disputes between the parties, look at the intention of the parties, and then move it on them. And then they made the non-signatory a party, they confirmed that.
All right.
Para 51.
That's just, I'm just saying that because they're dealing with the UNCITRAL law in a broad way, your lordships may consider it in your discussion.
All right. Thank you. Anything else, Mr. Advani?
So may I just, would your lordship like some broad propositions or right at the end? May I give a rejoinder, a short rejoinder?
You have your propositions. Do you have a note or something? You can maybe give us a note tomorrow morning on your proposition.
If your lordship, they're all ready. If I have lordship, may have them emailed to you, I can have them emailed to you.
All right. Why don't you send it to the courtmaster? He'll circulate it to all 5 of us.
The advocate on record will email it to you, sir.
Yes. It's ready. Just immediately send it to the courtmaster. So that. Mr. Solicitor, would you like to argue at this point? When would you like to argue?
But I don't know what time Dr. Singhvi will take. Because
Dr. Singhvi, first of all, who are
Who are you?
which side and what is the
Same
stand?
side as the said one. That's why
Okay.
the Lordship get all of this side. That's why.
That's what I wanted to ask. That's why I asked.
This time the solicitor is also largely on this side, but
I am also largely on that side.
So only.
Sometimes the solicitor and Dr. Singhvi are on the same side.
Yeah.
it's a rare, pleasant occasion where he's on the right side.
Factually incorrect, but it was a good one.
Now, let's.
So,
Only
for
difficulty-
other side's perspective, only Mr.
Lord,
Rikin Rai.
Your Lordship, I'll be a little candid, my lords. Your Lordships, consider continuing tomorrow.
Yes, we'll continue because we're now just 25 minutes short of
Because
the bails being removed for the day.
I know, Lords, there is a group of partners, my lord, Dr. Singh
No,
is also
not.
there, my lord.
Please wrap it up now. So we have broken up another bail.
I know.
Now, let's very.
I'll be,
Yes.
short, my lord, maybe in the second half.
Now, let's very briefly, I will go under 2 or 3 broad heads. The first is, I'm very briefly going, the Lordship will pardon us because I don't think we are prepared to the level of a constitutional bench. I said so in the morning. Lordship will put that caveat in front, but we'll try our best. I think most of us are taken by surprise, except Mr. Advani, because we have been a little underprepared. But that doesn't matter because fools do walk in where angels fear to tread. So perhaps I'm doing that for a constitutional bench. I should be better prepared. But the first head of my submissions is that this reference may not be necessary at all. And a constitutional bench, your Lordship knows, can answer the reference saying no reference arises.
It's divine deja vu.
No, it might save a Lordship's time.
Collection.
It might save a Lordship's time.
So,
Set of submissions is going to be from the 9, 10, 12 main cases to cull out. And we are not that ready, in a type.
Dr. Singhvi, we can also give you another option. You can sort of open your case right now, say 10, 15 minutes. And then we'll keep it partnered so that you have a little time to think on the night.
No, I won't finish today, Manas.
Anyway, all right, then
yes. I'll take about an hour and a half or 2 hours between today and tomorrow.
Then there's no
I'm now, whatever is there, I just want to
Yes.
deal with it.
Then you can't complain that.
No. As I said, Manas, I said, Manas, fools do tread where angels fear to tread.
None of us would complain. That was
No complaint, Manas. It's a pleasure to argue here. And whatever
It's a
is
pleasure.
there, assist
Not a
us
complaint.
to the best of our ability. It might not be as well prepared as the last 2 constitutional benches I've done, but it will be not too bad, I hope. Now, Manas, the second set of my submission is going to be an attempt to cull out some 10, 12 or 15 principles of why the group doctrine. This is after the first point. Your Lordship need not answer the reference at all. In the event your Lordship answers it, your Lordship should comprehensively reiterate and reinforce the group doctrine for about 15, 16 juristic principles. I'll give your Lordship those principles as the second head of my submissions. And the third head of my submission is to take your Lordships quickly through those relevant paras of the 10, 12 judgments, of which Mr. Advani has only cited 3, which bear out those principles. That's far as the broad 3.
The third aspect, Dr. Singhvi?
Third is for us to take your Lordship through the actual paragraphs. Only some very, very few paragraphs
Yes.
pinpointing from which those principles can be legitimately said to have a juristic basis, of which I will not repeat. Mr. Advani has dealt with those 2 or 3.
Dr. Singhvi would also like you to, at the end also, and maybe in the night, focus on those contradictions which Justice Suryakant has noticed in the judgment.
Yes.
Because assuming that we are with you,
Yes.
how do you iron out those contradictions? Because Justice Suryakant in his concurring judgment says uphold the doctrine.
Yes.
But a few of those contours, etc., just give them proper shape. That's the other thing.
Yes.
if I may add a 4th one,
Yes.
that will be the last submission, that it will only be a prima facie view of a referring court.
In a section 11
And
situation.
that the arbitral tribunal will thereafter take a decision whether
Yes.
it should be a party or not.
Yes.
Just view on that.
Likewise, Mr. Rai, when you argue, of course, you'll be arguing that there is no group of companies doctrine. We will not stop you from arguing that. But in the manner that you always fairly assist the court, you may also argue on a demerger that
Yes.
even if you apply the group of companies,
What are its contours?
then how would your contours? So
What
we'd
are-
like you to assist us there.
Yes.
As well. Especially because, they are in one side.
Yes.
So we'd like you
No,
to.
my submissions would be both.
Excellent. Thank you.
Where the group company may find a place in Indian law, and if it does, what are its contours?
Absolutely. That's
I'll
it.
address
Got it. Yes, Doctor.
We have also hard sets made in the course of day to day, but most of it will be Lordship soft copy. If it's not there, then we'll hand a hard set for some cases. Most of it, I think, is with the Lordship soft copy. Now, let's first on the first head. Well, I say with respect that both the learned judges who have formulated, well, A have formulated what might be called grounds.
Both the learned judges
have really given, in particular Justice Suryakant, has given us grounds, not really issues. I'll just make it good, Manas. Let me give you a point first.
Right.
Two minutes. The issue cannot be, as Justice Suryakant, with great respect, has formulated, for example, whether this group doctrine can exist in Indian jurisprudence independent of any statutory provision. That's the first issue as formulated. At best or at worst, the issue can be, which I don't think arises really, but can be theoretically, is a group doctrine created by judge-made law barred by the 96 Act?
Exactly.
This question is posing.
Well, judge-made law exists every day. So many things your Lordship says becomes the law, under 141, 142 especially. Therefore, Malas, it doesn't have to be found in a statute. Indian law is statutory, Indian law is common law, Indian law is a Lordship law, Indian law is customary law. So many sources of law. But yes, if the issue is taken to the extreme extent of saying that there is a bar in some sense of the 96 Act, then your Lordship will look at it and see if there is a bar. Or the other issue could be that your Lordship says Indian judgments, which are not yet a constitution bench, have wrongly brought in the group doctrine. Per se, it is wrong. That's a policy decision, if I may say so, a judicial policy decision of your Lordships. It should not be there. It's a wrong adumbration, it's a wrong importation. Beyond this, I don't think the Constitution bench has any other issue to decide. Behold, these two questions have not been formulated the way I have put it to your Lordships. They have not been formulated. Now, because the rest is ground, just turn to para 104, page 41 of Cox and Kings, Justice Suryakant's concluding paragraph. Para 104, page 41 of the SCC, whichever compilation your Lordship is using.
Reference order.
No, Justice Suryakant's, yes, the judgment, which is in Cox and Kings, which my Lord had read in full.
We are reading from the court's order.
Yes. No, the conclusion, para 104 is the conclusion of my Lord's judgment.
Page 903.
Oh, my Lord is using unreported judgment.
903.
That should be 48.
42.
Oh, I'm sorry. That might be compilation page, para 48 page.
This is the fourth judge.
That will be page 66.
Para 48. Whichever way, Lord, I was using the SCC. Now, the first issue at 104.1, or rather A issue A, capital A. Does my Lord have it? My Lord, Justice Roy has got it.
Brother, it is at page 928, page 928.
See, party wala hai. Whether the group of companies doctrine should be read into section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provision. Because it already existed before. It is existing. The Law Commission tried to clarify it. Suppose, Balus, there was no amendment to it. The only question then would be that is your lordship wrong in adumbrating a group doctrine, or should it be there in Indian corporate law, arbitration law? Theoretically, this issue is really not arising and would not arise in a situation. I'm assuming that 8 is not amended. Your lordship makes declaratory amendments, codificatory amendments in the legislature. Second issue is whether the group of companies doctrine should continue to be invoked on the basis of a principle of single economic reality. That's what is actually a ground. If the group of companies doctrine can have many juristic bases, I'm going to give your lordship 15 odd bases for that. One of those bases is single economic reality. Now, is there a juristic basis correct or not? Of course, your lordship can opine on it. But it is clearly there in a lot of case law. Third is whether group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. That's either a ground or a conclusion. The lordship really cannot decide it in this form. Actually, both fellows implied consent or intent to arbitrate.
Reformulate.
Yes.
We'll put it to you that this is how it could be reformulated.
Yes.
In the Arbitration Act,
Yes.
reading section 7 with 2H,
Yes.
is it not the intendment of the Parliament that only parties who are signatories to the agreement will alone be entitled to? It does not enable, by implication, bringing a party who is not a part of the contract.
I'm grateful. That's really, Manus, your lordship is making it narrow and make it wider against me. It's not what I said in the beginning. Does the 96 Act not permit the declaration of a group entity doctrine? Whatever, whether 2H does not or 7 does not, does, Manus, the Act inhibit?
No,
That can only be a bar.
Statute's own expression.
Yes.
Does it permit anybody other than a party to the contract?
Very well. That's the positive way of putting it or negative, either.
When I was typing, I took down your first submission as.
Yes. It's the same thing.
When you said both the learned judges have furnished grounds and not issues. The
Yes.
first point which I took down was, is the group of companies doctrine concept which is created by judge-made law barred by the 1990s?
Barred. Now you can use different words. Don't use barred.
The other is saying barred specifically by
Permitted.
218H
Permitted.
section 6.
But the only thing with permitted is one. Suppose it is not explicitly permitted. Suppose, I'm not saying.
It may not be barred according.
Exactly. It will not prevent your lordships from adumbrating it. Your lordship does it every day.
But it's not, no, you know, that's not the.
Does not contemplate. Your lordship uses more to contemplate.
It is not explicitly permitted. But could we be reading, would section 7 be read so as to exclude anything but a written agreement?
So does the 96 Act not contemplate that a person who is not a signatory can be? That's a better way.
That's right.
No problem.
That's the point.
No problem on this. Does the 96 Act contemplate a person not a signatory to be part of an arbitration process? I'll formulate it more clearly with this for tomorrow, but that's barred maybe too extreme, permitted maybe affirmative. Lordship will take a middle view.
This we put it to him so that you can reflect on it in the context that agreement can be implied under the general law of contract and arbitration. Number two, arbitration is specifically a matter of contract between the parties.
Implied consent
It's
is
not a
one,
public law. It's not a
implied
public.
consent is one of the basis, juristic basis of the
Let's
15
see, I'm
basis.
just putting it to you.
Yes. So, that would be one issue. The other would be a larger issue I'm putting against myself. That does your lordship as a constitution bench think it fit that there should at all be a concept in Indian law called group of doctrine? I mean, group of companies doctrine. Namely, that all the judgments are wrong, which have adumbrated it. Judgment should not have adumbrated it. I mean, it's the same thing overlapping, but it's a larger issue. That judicial policy of your lordship does not contemplate because it's highly unjust, it's highly oppressive, it's unnecessary, it is productive of mischief. Whatever your lordship is, that's your lordship judicial policy. That's really only the issues arising according to me. You can put it in different ways, Balus. These are, now see number 4, Balus, D. It's one of the grounds, Balus. They're all bases. Piercing the veil, alter ego. These are all bases, Balus. Now let us turn to Balus just.
Maybe what we'll do is we'll rise right now.
Yes.
So that you have a little time to reflect.
Yes.
We know always how you formulate, Sometimes your number 7 is our number 8 or point number 6 is our number 5.
When I oralize it, when I write it down, it is
I know that's right. It's on a lighter vein, Dr. Ingrid. So we'll give you, so then tomorrow morning you will have, you'll have the whole evening to reflect and then. And then Mr. Solicitor will like to do. So it's a very important central act. This will have a bearing on the very course of Indian arbitration.
Lord, I have.
So we are happy that you are intervening because as the Parliament having.
After my Lord's decision.
No, we were suggesting that why is it that the Law Commission's recommendation was not followed? Just check it out.
Just check that. I have already requested the Law Secretary that you give me entire details,
Right.
whether it was considered, whether it was a conscious decision not
Or
to.
just a casus almost.
I have one request, my lord. I'm in Article 501.2, item 501.2. After my learned seniors complete, I may be given 15 minutes to make my submission.
Of course.
Give your pleasure.
That is just.
May I also find a compilation?
And if you can give us a short note of 2 pages, it's always better because then it becomes focused. Yeah? 2.5.
We'll also circulate whatever we made in the
Certainly.
email soft copy.
Certainly. Mr. Rai, your note is.
Obliged.
There is a coffee cup in his bookshelf on which are imprinted the words Rockstar DYC. And for many who come in touch with him, a rock star is really who he is, and you're just about to find out why. Son of an illustrious father, father to two illustrious sons, Justice Dhananjay Yashwant Chandrachud is the 50th Chief Justice of India. I don't know how many people sitting here know this, but Chief Justice Chandrachud used to moonlight as a radio jockey in his early 20s for the All India Radio. He RJ'd for programs like Play It Cool, A Date With You, and Sunday Requests. His friends from school call him Danny, his parents call him Dhanu. He calls himself an accidental lawyer who loves cricket and music. Those who come in touch with him consider him one of the finest judicial minds in our country. Ladies and gentlemen, this is the first time ever any sitting Chief Justice has agreed to take live questions at the conclave. And it is my absolute delight and our collective pleasure to welcome to this, the 20th year of the India Today conclave, legal rock star, India's Chief Justice, Justice Dhananjay Yashwant Chandrachud. Can we have a warm round of applause, please? Justice Chandrachud, I want to start by asking you straight up about the challenges India's judiciary faces. At this moment, if you look at the number of pending cases in this country, there are about 4.32 crore total pending cases. 69,000 of them in the Supreme Court, a backlog of about 59 lakh across 25 high courts. Could you start by telling us, all of those who are watching you here at the India Today conclave, watching live on TV and on social media, about your broad vision to transform, modernize India's judiciary? Let's start from there. Justice Chandrachud.
Well, it's true that we have a large backlog of cases, but another way of looking at it is, I think it's reflective of the faith of the people in coming to court in the first place, which is not to justify the backlog. We should be discharging the faith of the people by being more efficient and by reducing the backlog. But that's just an indicator of the kind of faith people have. It also shows that there is a dearth of adequate infrastructure in the judiciary. Our judge to population ratio is not commensurate with what it should be in a country like ours. That's another problem. The third problem, of course, is the lack of infrastructure in the district judiciary. But now coming to your question about my vision, I think what we need to do is completely modernize the Indian judiciary. Our model for judicial administration has been based on the colonial model which we inherited from the British, which is that people have to access justice. It's also reflected in the design of our buildings, these grand colonial buildings, which were intended to sort of create a sense of fear and awe about the court in the minds of people. And I think that colonial model now has to give way, because justice, to my mind, is not just a sovereign function, which it is, but justice is also an essential service which we provide to our citizens. And part of my mission of dealing with where we should be in the next 50 or 75 years is to transform the Indian judiciary with the use of technology. We saw that in the COVID-19 pandemic. The COVID-19 pandemic was unanticipated, possibly unexpected as well. We couldn't have shut down the doors of courts. We had to keep our courts open because you have to answer the need of citizens who seek bail. Their personal liberties are at stake, their lives are at stake, their careers are at stake. So we launched a whole system of video conferencing. And if you'd like me to share the data which I have with me, the kind of work which we did on the video conferencing platform in the pandemic is unprecedented in any part of the world. So my vision now is that now that hopefully COVID is behind us, or almost behind us, as we would like to, because we all lived in a sense of optimism, we now need to look at technology beyond COVID. and we need to modernize the Indian judiciary. We have already taken a large number of initiatives towards having a more transparent, a more open judiciary. We are live streaming the proceedings in at least some of the most important constitution bench cases. Opening up the court's processes to citizens by live streaming them is part of my mission because it enables citizens to understand what goes on in the court. Many citizens would actually turn up feeling that so much of the work which is done in the court is so very boring. But there is a great message which we would like to send to our citizens, because the smallest case which comes to us commands the same degree of attention as maybe some of the seminal constitutional cases which we do.
How's the experience with live streaming been so far? One of the things we saw in Parliament with our netas is that the moment the cameras are on, the grandstanding goes up. Are you concerned, Chief Justice, that as more and more cases are live streamed, you'll start seeing lawyers being more filmy and more theatrical in their arguments before you?
Well, in a lighter vein, you always have some professionals who would be given to grandstanding, right? Whether you have a camera in front of them or otherwise, it's not going to make a difference. But I have a sense of optimism, at least my experience thus far. All technology has the good part and the flip side. So likewise, live streaming also has the more difficult part of it. For instance, I'll give you the flip side as well. Very often we are dealing with very sensitive cases involving, say, marital privacy or gender assault or sexual violence against minors. Should you have live streaming in such cases? Obviously not. But therefore, we have the ability to now enable the judge in charge to stop live streaming where you feel that the sensitivities of the case far outweigh the public interest in a transparent court proceeding. Some lawyers would grandstand, some private litigants, some litigants in person may do that. But then we must always look at the benefits as well to be gained when you make an overall assessment in a holistic perspective.
You've spoken in public about your desire to Indianize the Indian judiciary. Do you want to explain what you mean by that, to make justice more available to Indian citizens in Indian languages? How do you go about Indianizing the judicial system?
I think the first point where we have to start Indianizing the judiciary is in terms of the language of discourse. The language of discourse is not just English in our district courts. For instance, when evidence is given in a murder trial in Maharashtra, the witness would be speaking in Marathi. When a witness deposes in a murder trial in Uttar Pradesh, the witness deposes in Hindi. But the language of discourse in our higher courts, the high courts, and in the Supreme Court is English. Now, that may be a part of our colonial inheritance. It's also because, English is the language in which we have the greatest felicity in terms of our statutes, the judgments. But if we have to truly reach out to citizens, we have to reach out to them in languages which they understand. And we've already started that mission. Just to give you an idea, there are about 34,000 judgments of the Supreme Court from 1950 until date. These 34,000 judgments were available in an official reporter called the Supreme Court Report. So if a private citizen had to access these judgments, you have to subscribe to a private software provider. They are doing excellent work, no doubt about it. But how many young lawyers or citizens across the country can pay 30,000 or 50,000 rupees a year by way of subscription for these kind of reports? So the first thing which I did when I took charge on the 9th of November last year was to digitize all the 34,000 judgments. We have a free judgment text portal. We have a search engine so that these judgments can now be searched by a citizen in the country, or for that matter, a citizen across the world, anybody across the world. But we haven't stopped at that. We are now using artificial intelligence and machine learning for the translation of these judgments. We have used a module which has been prepared by a very distinguished professor at IIT Madras. And we are now translating all the judgments of the Supreme Court in every Indian language which is recognized by the Constitution. And by doing so, we want to reach out to citizens in the language which they follow. Just last week, when we were hearing the Constitution bench hearings in one of the very sensitive issues which is before the court, and we have reserved judgment now, we have live transcripts of proceedings. So when the lawyer is arguing, we have simultaneously a transcript which is relayed on the screen in the form of a complete text. So then the court becomes a court of record. This also increases the sense of accountability, because citizens then know what is argued, As judges, we are accountable also because we are then responsible for dealing with all the arguments which are made before us. The accountability is, I think, on the part of us as a judicial institution as well.
One of the biggest questions, Justice Chandrachud, facing the Indian judiciary at this moment is the manner in which judges are appointed. We've seen a lot of public backlash from the government of the day, asking for changes in the collegium system, which the law minister and others in government believe is not transparent, should be more open, shouldn't be like a judges' club. Could you spell out what you think is right and wrong with the collegium system and the manner in which we appoint our judges to the high courts and the Supreme Court?
Well, you know, as a Chief Justice of India, I have to take the system as it is given to us today, which is that the collegium system is the prevalent system for appointing judges. Yes, there have been demands for greater transparency, but I must tell you how we work. For instance, if we are making appointments to the Supreme Court of India, the Chief Justice and the 4 senior-most judges, I have actually 5 because my successor, Chief Justice of India, was not otherwise a part of the collegium, so mine is a collegium of 6 judges. We look at the judgments which have been delivered, say, in the last 3 years by the judges of the High Court. And the parameters which we apply for the selection of judges are well defined. First, we look at merit. We look at the professional competence of the judge. We constantly analyze judgments of the High Court judges when they come up in appeal before us. On an average, we are dealing with about 200 cases every week. So those are judgments of the High Courts which are coming up before us, so we assess those judgments. But in the collegium, we all read the same judgments at the same time. So we circulate the judgments of the High Court judges who are in the zone of consideration. Apart from merit, the second important consideration which we go by is seniority, because after all, this is a service. It's a service. Judges of the High Court are elevated to the Supreme Court. Third important point which we emphasize, that's the need for a broader sense of inclusion. Inclusion in terms of gender, inclusion in terms of the marginalized communities, persons belonging to the scheduled castes and the scheduled tribes who must have an equal opportunity to aspire for higher judicial and constitutional offices. Apart from the need for including more gender, having a more gender-inclusive judiciary and the marginalized, we also want to bring more minorities into the court. But that is not at the cost of sacrificing merit. Each one of our colleagues who is chosen because she was a woman is as competent as any of her counterparts, the male judges. Likewise for the minorities or for the scheduled castes and scheduled tribes, they're as competent as any other judges we have chosen in the recent past. The next important factor which we consider is the need to have a broader sense of dispersal of judicial office throughout the country. It shouldn't be that judicial office in the Supreme Court is confined to only 1 or 2 or 3 high courts. So to the extent that it is possible, we try and ensure that we give adequate representation to different segments, different high courts, different states, different regions in the country when we are making appointments to appointments to the Supreme Court. We also consult judges who have routed through that high court and who are judges of the Supreme Courts. For instance, my parent high court was the High Court of Judicature at Bombay. I was Chief Justice of the Allahabad High Court for 3 years. So when a judge from Bombay has to be appointed, I am consulted. If I have to be appointing a judge from the Allahabad High Court, of course now I'm the Chief Justice, but when I was a puisne judge, I would be consulted for making, and judges give extremely transparent and clear opinions on what they feel. In the high courts, it's even broader because the high courts are looking at lawyers who are fit for appointment, and there are 2 sources of recruitment to the high court, the district judiciary, and the whole track record of the district judiciary is maintained on paper. You have the annual confidential reports. You have a whole dossier on each judge which is developed as they progress through the service. When lawyers are to be appointed, the same procedure is followed, and there is an equal involvement of various stakeholders in the system. For instance, once the High Court Collegium makes its recommendation, the file is processed at 2 levels. It comes to the Supreme Court, the Government of India, and the Government of the state, so that the Chief Minister of the state, the Governor of the state responds to the appointment which is recommended by the High Court Collegium. At the same time, the file is processed by the Intelligence Bureau to see if there are any adverse intelligence inputs. The file is then, it goes to the Union Government in the Ministry of Law and Justice. The Department of Justice sends the file to us with its annotations. We then consult our judges, after which the file is sent back to the government, then goes on to the Prime Minister's office and then to the President of India.
The Supreme Court gave an order recently which said that going forward, election commissioners and the chief election commissioner would be appointed in a panel which includes the Prime Minister, the Chief Justice and a leader of the opposition. So it's not just the government picking the next EC. That is a fantastic idea. Many in government said, but that's also reason why judges should be appointed by people other than just judges. How do you look at all the pressure that's coming your way, saying that the collegium system is not transparent, that this needs to be opened up in a way that judges aren't judging judges, that other people can weigh in, as is the case in many countries internationally?
Right. Now, we have adopted a model. We have a career judiciary. Unlike, say, the United States, where a politician can become, a Secretary of State can theoretically, and you have had Secretaries of State who have become Chief Justice of the US Supreme Court. We don't follow that model. We follow a model of career judges coming to either the High Court from the district judiciary, or career judges from the High Courts coming to the Supreme Court. We, of course, have members of the bar as well coming directly to the Supreme Court as to the High Courts. Since you did mention the issue of transparency, let me emphasize two facets. There's a transparency which operates at two levels. Transparency of the process of appointment and transparency in the terms of the choices that you make when you're appointing people. The process has to be completely transparent. And that is why in recent times, we have been putting out onto the internet, onto our website, the collegium resolutions. And those resolutions tell society at large, our citizens, what are the parameters we have applied in the selection of judges. Let them judge, let them critique us. I'm not saying that any system is perfect, but this is the best that we have developed. And the object of this system, why was this collegium system designed? It was devised for the simple reason that the independence of the judiciary is a cardinal value. And you have to insulate the judiciary from outside influences if the judiciary has to truly be independent. That is the underlying feature of the collegium. That's the underlying purpose of the collegium. But our processes are becoming now transparent. We have defined what the parameters are. We put our resolutions on the website so that people know whom we have selected, why we have selected them, what are the yardsticks that we have applied. Apart from the processes, and this is the most sensitive aspect which I must share with you because a lot of people perhaps wouldn't know about this. When we consider names for appointment as judges of the High Court or of the Supreme Court, we are also dealing with people's lives, particularly in the High Courts. Very often the people whose names are under consideration, we look at diverse set of aspects pertaining to their personal lives, their professional lives, their personal lives insofar as they are relevant to the discharge of judicial duties. I have no cause about somebody's personal life if it has no connection with their judicial duties. But when we deal with these very personal, intimate, sometimes very, very intimate and private aspects of people's lives, we have to be conscious of the fact that you can't, in the process of selection, open up every aspect of their lives to society at large. The consequence will be that good people will then say, sorry, I'm not willing to put my personal life on trial in this particular way. So if you have to have good people, you must also trust your decision makers to make those choices.
Law Minister Kiran Rijiju was at the conclave this morning, and he was quite upset with the manner in which the Supreme Court had chosen to make public the government's reasons behind withholding permission for somebody to become judge, saying that this is between the government and the judiciary. This should not be made public. There are matters which should be kept private. He didn't like the fact that you were starting to make these public.
Well, let me join issue with the Law Minister. He has a perception, I have a perception, and there's bound to be a difference in perceptions. And what's wrong about having a difference in perceptions? Sometimes there's a difference, but we have to deal with differences in perception even within the judiciary. I dare say there are differences in perception even within government. But we all deal with it with a sense of robust constitutional statesmanship. So first and foremost, I don't want to join issue with the law minister for his perception. I respect his perception, and I'm sure that he has a great deal of respect for ours as well. The reason why we put this on the website is in pursuance of the desire of the present collegium to meet the criticism that we lack transparency and a genuine belief that opening up our processes will foster greater confidence in our citizens